Well, good afternoon. Very happy to welcome everyone here today. Today we're pleased to welcome Sir Bernard Eder, who is the former judge of the High Court of England and Wales, and he will be speaking to us about issue Estoppel under the New York Convention. So I'll keep my intro brief and allow the full time to Sir Bernard Eder. Thank you.
Thank you. Thank you. Oh, I hope, first of all, can you all hear me? Yes. Thank you. Well, it's a great privilege and to be here today, particularly because there's something else going on in England at the moment, and the news overnight looks as if it's more hopeful than it might otherwise have been. Otherwise, I might have applied to stay in Hong Kong, but everything looks good. Issue Estoppel under the New York Convention. The New York Convention is rather odd. It's one of the most successful treaties in the world. It has its own website. If you've never looked at this website, it is worth looking at. Some 155 state parties have joined it. I think it is one of the most successful, if not the most successful, treaty in the world. And if you go to that website, you will see it is absolutely magnificent. It has a section in it where virtually every case anywhere in the world that is referred to the New York Convention, you can find referred to and considered. It is a real wonderful website. However, the point that I'm going to be discussing today is really, really difficult. This is a picture, I should tell you, of my wife when I told her that Ed Miliband might come into power in England. That's not true, I should tell you. That is not true. But the topic that I'm going to discuss today is, in fact, really, really difficult. The lecture falls into two parts. I hope to speak for about 40 minutes, something like that. But I regard this as a seminar, really. So if anyone wants to interrupt or discuss anything, please do so. Otherwise, I hope there will be time for questions at the end of it. And I will come back to this lady at the very, very end, when I discuss a particular case that I decided in the English High Court in London. And I am not here to tell you that my decision was right or wrong, but I am here at least to provide at least an opportunity to discuss whether it was right or wrong. So we will come back to that lady in a moment. Why is it so difficult? Well, we start with the relevant part of the Convention, which is Article 5. I hope you can read it. Much of the first part of the next few minutes will be familiar to many of you. At first blush, this article is very, very odd. It is concerned with the recognition and enforcement of awards. But the way it is phrased is odd, because it doesn't tell you when an award will be or should be recognized and enforced. It is put negatively, so it tells you when it may not be enforced. So the structure of Article 5 is very, very odd. It tells you, therefore, when recognition and enforcement may be refused. And the two important words in Article 5 are the words may and the word only. So you will see the opening part says recognition and enforcement of the award may be refused at the request of the party against whom it is invoked only if that party furnishes to the competent authority where the recognition and enforcement is sought proof that, and there are various subparagraphs that are important, but I'm not going to focus on those today. I'm going to focus on subparagraph E, which is the award has not yet become binding on the parties or has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made. Now, two things there. First is that subparagraph E falls into two parts, that is, the award has not yet become binding on the parties, which might be said to be an abstract question. Is the award binding or is the award not binding? And then second part goes on, or has been set aside or suspended by a competent authority of the country. I'm going to call it the country of the seat. So that subparagraph E falls into those two parts. The first part, as I've said, the award has not yet become binding on the parties, an abstract question perhaps, and secondly, whether it has been set aside or suspended by the court of the seat of the arbitration. Well, that's paragraph 1, and I'll come back to that in a moment. Subparagraph 2 also provides that an award or recognition and enforcement of the award may also be refused if the competent authority, again, that is the enforcement state, and then in subparagraph B, the recognition or enforcement of the award would be contrary to the public policy of that country. And that country is the enforcing country. And that is important as well. The really difficult question that this lady was worried about in my first slide is really this. What happens if an award is set aside in the country of the seat of the arbitration, and then can it be enforced still in some other country? One might have thought that if an award is set aside in the country of the seat, that I will call country A, once it is set aside, it has gone. But can it still be enforced in a third country where, for example, there may be assets? And the question is difficult for a number of reasons. The first is we're not looking at a single domestic system of law. It has to be considered in the context of an international context. And if any of you have never read Emmanuel Gaillard's book on the theory, the legal theory of international arbitration, I have no shares in the publishing company, but I strongly recommend you go off and buy it or at least read it. It is a tremendous study of arbitration in the international context. And the problem that I've identified here is that there is a wide divergence of views in the international context between, on the one side, there are two theories. One is the territorial theory, and the other is the delocalized theory. The first one, the territorial theory, sees an award as essentially anchored in the territory of the seat of the arbitration. And the latter, the delocalized one, sees an award as having an independent status, independent of the territory of the seat of the arbitration. And there are those two extreme views. And somewhere in the middle, there are other views as well. And I can explain that better by showing you various quotes from the two main countries which reflect, in a way, the two extreme views. The first is, screen 7, the first is in France, and you will see the two quotes that I have given to you. One is from the Bargues-Argron case, and the other one is the Poutre-Bali case. And the Bargues-Argron says, it is not, this is the Paris Court of Appeal, that an award is not integrated into the legal order of the state of the seat, with the consequence that it's possible setting aside by the courts of the seat does not affect its existence by precluding its recognition and enforcement in other national legal orders. And then the Poutre-Bali case, which is the Cour de Cassation in France, which I think is the highest court in France, is that an international award which is not anchored in any legal order is a decision of international justice whose validity must be ascertained with regard to the rules applicable in the country where its recognition and enforcement are sought. And the Poutre-Bali case is, in some respects, certainly to an English lawyer, a surprising decision. That is an English arbitration award, an arbitration award with the seat in England. The English High Court set aside that award. The reasons don't matter. The claimant went to France and then got enforcement of that award in France. So in France, they enforced an award that the English court had set aside. And if we go back just for a moment to the New York Convention and see how that fits in with Article 5, you'll see, if you jump to 1E, you'll see it talks about the award. I'm jumping to the second line in E. The award, in that case, had been set aside by the court of the seat of arbitration. It had been set aside by the English court. But under Article 5 of the Convention, that does not mean that under the New York Convention, that the enforcing court must refuse enforcement because of the important word may. So in that context, in the Putrabali case, the fact that the English High Court had set aside the award did not mean, under the New York Convention, that the French court was bound under the Convention to refuse to enforce it. It may refuse to enforce it, and in fact, for various reasons that don't matter, the French court decided not to. If we then jump, that's the French view, and France is not alone in this. There are countries that are similar to France, but if we go to the USA, there's a case called Termo Rio, and I've just taken one sentence out of this. An arbitration award does not exist to be enforced in other contracting states if it has been lawfully set aside by a competent authority in the state in which the award was made. And the United States takes I'm not sure a conclusive view, but a general view, that where an award is set aside in the court of the seat of arbitration, it generally, anyway, will not be enforced under the New York Convention. In England, the position is rather, I'm not sure, uncertain. It certainly hasn't been determined by the Court of Appeal. There are various authorities that are referred to, and I have cited them here. I don't want to spend a lot of time on this, but there is a terrific article in the recent edition of the Chartered Institute of Arbitrators law journal called Arbitration there, by two people called Tweedale and Tweedale at those pages, and they cite the various English courts that talk about this problem. In particular, there's a recent case of Mr. Justice Simon, that's the last case referred to in EWHC, which is generally to the effect that where an award has been set aside at the seat, it should only be enforced in England if recognition of the order setting aside would be, it should not be enforced in England if recognition of the order setting aside the award would be impeachable for fraud or as being contrary to natural justice or otherwise contrary to public policy. And EWHC was an important case, just to tell you briefly about it. The claimant succeeded in obtaining awards in its favor in Russia. So this was a case of a Russian seat arbitration awards. However, in Russia, in favor of the claimant, however, in Russia, those awards were set aside by the Moscow Arbitrage Court. Notwithstanding that the awards had been set aside by the Moscow Court, the claimant sought to enforcement proceedings in Holland. Initially, the Dutch District Court refused leave to enforce the awards on the basis that they had been set aside in Moscow. The matter then went to the Amsterdam Appeal Court. The Amsterdam Appeal Court reversed the decision and gave leave to enforce the awards. So the awards were given, there was leave to enforce the awards in Holland, even though they had been set aside in Moscow, applying local rules of private and domestic international law in Moscow. So that was the position that pertained then. You had Moscow awards set aside in Moscow. The Dutch court then gave, nevertheless, leave to enforce. There was not enough money, I think, in Holland, and the claimant then sought to enforce the original awards in England. The question then arose, well, the Dutch courts had held that the awards could be enforced in Holland, notwithstanding the fact that they'd been set aside by the Moscow courts. And the question that arose in England was whether or not the decision of the Dutch courts created an issue estoppel such that when the claimant came to England, the claimant could say, well, the Dutch courts have decided to allow enforcement, notwithstanding the awards have been set aside in Moscow, and therefore held by Mr. Justice Hamlin, there was an issue estoppel created by the decision in Holland to permit enforcement in Holland. That was then overruled, or the relevant part of it was overruled in the Court of Appeal in England on the basis that there could be no issue estoppel in England because the decision in Holland was based upon Dutch public policy. And when the claimant came to England to enforce in England, England was concerned with its own public policy, and a decision by the Dutch courts of its public policy was not sufficient to create an issue estoppel on that point in England. So in England, the matter then went forward, and the Court of Appeal decided that there was no issue estoppel. But, and this is the important point, is that inherent in the decision of the Court of Appeal in England is that there could be an issue estoppel apart from the question of public policy. So if the Dutch court had decided that, not on the question of public policy, but on some other point, then there could be issue estoppel. So the EWHC case is English Court of Appeal authority. Put public policy on one side, but is English Court of Appeal authority, or at least inherent in that, to the effect that issue estoppel can arise in this context. And the decision of Mr. Justice Simon, it then came back, as I've said, the Court of Appeal decided it should go ahead. It then came back before the court again recently, this is Mr. Justice Simon's decision, as to whether or not the award was or was not enforceable. And he decided, as I have said a moment ago, that the original, now we're not in the case of issue estoppel, and the question was whether, as a matter of fact, the awards would be enforceable or not, and that decision has been followed by Mr. Justice Walker in a very recent case called Malicorp. That's M-A-L-I-C-O-R-P, but it's not on my list. And then I've tried to describe this in a diagram to understand where all this fits in. So if you look at it on the left-hand side, you will see you have country A, which is the seat of the arbitration. It's a New York Convention country. You have an award, and the award may be set aside locally in that country. Can the claimant then go to, I've called it country B, which is also a New York Convention country? Can the claimant then seek enforcement of the award in that country? And that will turn on Article 5. Now that country, country B, may say that the award is enforceable, or it may say it's not enforceable. Let us assume that the answer is no, it is not enforceable for whatever reasons. So again, just to clear the air, you have an award in country A, it is set aside in country A, you then go to country B, and you seek to enforce it in country B. There are two possibilities under the New York Convention. Doesn't necessarily follow, as I've said, but let us assume in New York, in the country B, the court says, no, you can't enforce. What can you then do? Can you then forum shop and go to another country and try to enforce that award in country, which I call country C, another country? And the argument may be, well, the decision of the court in country B that the award is not enforceable creates an issue estoppel. So when you go to country C, the decision of that court means that there is an issue estoppel in country C. If we go back to the EWHC case that I've just explained, in Holland it was held that the award was not enforceable, that the award was enforceable notwithstanding the award had been set aside, and in England it was held that that did not create an issue estoppel. One then gets into the interesting theoretical question is what happens if in country B the court has decided that the original award is not enforceable? No. But when you then go forum shopping to another country, in country C, the court decides that it is enforceable. You have two decisions of two courts under the New York Convention, one saying it is enforceable and the other saying it is not enforceable. Then, let's assume there are not sufficient assets in country C. Can you forum shop and then go to country D? And when you get to country D, can the claimant then enforce it there? Now, one possibility, it might be said, well, the decision first in line or first in time, country B said no, that creates an issue estoppel. Or is the foreign court in country D faced with two decisions, one in favor, one against? And what does country D do? I do not know the answer to that question, other than I go back to my lady right at the beginning. Now, that is one of the problems of, that's the background to the question that we have to consider here. When we go back, that's the problem, or a number of the problems. If we then step back and think, what are the general principles which underlie issue estoppel? And they're probably well known to you. I've summarized them here. Certainly in England, everything I've said is on the basis of English law. You'll see two cases, the Carl Zeiss case and the Senna number 2. There are 4 basic conditions. I summarize them. The earlier judgment must be given by a foreign court of competent jurisdiction. The judgment must be final and conclusive on the merits. There must be identity of parties, and there must be identity of subject matter. All of that is, I say now anyway, relatively simple. It was rather controversial, I should tell you, at the time cases were decided, but is now relatively straightforward. And probably a useful summary, a decision in the Good Challenger, a decision in England in the Court of Appeal, and I've given you certain further points that Lord Justice Clark identifies in his judgment, and that is, it is irrelevant that the English court may form the view that the decision of the foreign court was wrong, either on the facts or from a matter of English law. The courts must be cautious before concluding that the foreign court made a clear decision on the relevant issue, because the procedures of the court may be different, and it may not be easy to determine the precise identity of the issues being determined. 3, the decision of the court must be necessary for its decision. All of those are important and flow from the general principles that I've identified. But the 4th is really important, and that is the application of the principles of issue estoppel is subject to the overriding consideration that it must work justice and not injustice. And I rather suspect that looking at the problem that we have been considering, it may be that that last consideration is the one that may be the focus in future cases. That issue estoppel is not a doctrine which is to be applied indiscriminately to a particular case. And then I come to a number of recent cases. The first is the Good Challenger itself. Again, there were very complicated facts, and I will try to simplify them. In that case, you had an English seat arbitration. The claimant in the English seat arbitration obtains an award in its favor. Then there are enforcement proceedings sometime later against the defendant in Romania, so in country B. An issue arises in Romania as to whether or not those proceedings, the enforcement proceedings, were time-barred in Romania. The Romanian Supreme Court refuses to enforce the English arbitration award on the ground that, under Romanian law, a foreign award can only be enforced if it is not time-barred, both under Romanian law and under the law of the seat of the arbitration. A two-limb requirement. Held by the Romanian court that it was time-barred, that the proceedings in Romania were time-barred under Romanian law. But the Romanian court went on to hold, or at least express a view, that the proceedings would also have been time-barred under English law. So the Romanian proceedings came to an end. The claimant failed to enforce in Romania. Having failed to enforce in Romania, the claimant then comes back to England and tries to enforce in England, which again, now we're going back to country A. The question that arose then in England was, did the decision of the Supreme Court in Romania that enforcement was time-barred create an issue estoppel for enforcement back in England? Held both by a deputy judge and indeed upheld by the Court of Appeal, no, there was no estoppel in England, because the conclusion reached by the Romanian Supreme Court was not, and the word was not fundamental to its decision as a matter of English law. Therefore, no issue estoppel. You remember I said that under Romanian law, the requirement of creation of an issue of the time bar was that it had to be time barred both under Romanian law and under English law. In effect, what the English court said, and I'm summarizing it perhaps badly, it said, well, it may be time barred under Romanian law. The Romanian court might have decided it's time barred under English law, but the fact that its view was that it was time barred also as a matter of English law was not fundamental to its decision in Romania, because it was sufficient in Romania that it was time barred in Romania. So held that there was no time bar in England. But the important point for present purposes is this. Again, like UCOS in the Court of Appeal in England, inherent in the decision is the fact that an issue estoppel could have arisen by reason of a decision in the foreign court, though it didn't on the facts in that case. I now come to my own decision in Diag last year, and I don't know how many of you know Diag. I am not here to tell you the decision is right. The point I should tell you right at the beginning was conceded in my case. I remember telling counsel, and I travel around the world, because Diag has caused a great storm in the commercial world. I won't tell you the person, but there is an article online that says something like, about Diag, I have great respect for the English judiciary, but on this occasion, the judge fell asleep. Now, I want to tell you that the judge did not fall asleep. That doesn't mean I got it right or wrong, but the point was conceded in Diag. And let me explain what happened. It's very simple. In Diag, one had a Czech Republic award in favor of a claimant for a lot of money. I think it was nearly $300 million, something of that kind. The arbitration agreement was odd, or perhaps unusual in Czech, because it provided for what I might describe as an internal appeal process. In England, there we have that in trade arbitrations, like in GAFTA. So you have an arbitration, an award produced, but as a matter of the arbitration rules of the association in that case, but in Czech, the losing party has a right of appeal as part of the arbitral process and can go to a higher level of a higher tribunal, which is part of the tribunal process. In Diag, the award, as I say, was in favor of the claimant, and the losing party gave notice to appeal in the internal arbitration. There was a major issue, however, as to whether that notice of appeal was valid or not, whether in particular it had been served in time and served on the right party. So there was an issue as to whether or not the internal appeal process had been triggered properly. If it had been triggered properly, then the appeal process was still ongoing and the original award was not binding. If, on the other hand, the notice had not been given validly, then the original award was binding. That was the issue. And if we go back to the New York Convention and we look at the words in 1E, the award has not yet become binding. That was the focus of the words in Diag. So the question in Diag was the original award binding or was it not binding? And that all turned on the question of whether the notice was correct or not. The claimant, however, didn't seek to enforce that in Czech or do anything in Czech. There were a whole lot of proceedings in Czech that don't matter. They went to Austria, and in fact I think they went to New York and they went to Paris. They went all around the world. Don't worry about that. Particularly they went to Austria and they sought to enforce the original award in Austria. That went up to the Austrian Supreme Court, held by the Austrian Supreme Court, that the award was not binding. Don't worry about the details, they were unbelievably complicated. But the Austrian Supreme Court held that the award was not binding. The claimant then came to England before me and said, we want to enforce the award in England. The question, or at least one of the many questions I had to decide was the decision of the Austrian court that the award was not binding, did it create an issue estoppel in England? I held, well, first of all, it was conceded that an issue estoppel could arise, but I held that the Austrian Supreme Court decision created an issue estoppel in England. I did that in one little paragraph, I should tell you. But I went on to hold anyway that even if it did not, forget about issue estoppel, the award was not binding in England. Looking back, I have to say I should not have decided the question of issue estoppel because I decided the other issue was irrelevant. And it may still be irrelevant. But I decided that there was an issue estoppel. Why? And broadly speaking, I've given you 3 reasons. In fact, there were 4 reasons, actually. The first is it was conceded. Secondly, general principle. I decided this was a decision, you remember the general conditions of issue estoppel in England under the Senar and Carl Zeiss. It was a decision of the Austrian Supreme Court on the merits. It was conclusive in Austria. There was no difficulty with any of that. It had nothing to do, unlike EWHC, with questions of public policy. It was a question of law decided by the Austrian Supreme Court. So as a matter of general principle, I decided that that's the first reason. The second reason was that there was an issue estoppel was consistent with the view expressed in the leading textbook, I.C. Morris, and various cases there referred to, Owens Bank and House of Spring Gardens, not in the context of arbitration, I should say, but in the context of enforcing judgments. And thirdly, it was consistent with the view expressed in EWHC Capital, and I've said, but NB, public policy and justice. So I decided that there was an issue estoppel in that case. I will come back in a moment to whether I think that decision of mine was right or not on that particular point. But very briefly, there is no doubt that there are other authorities around the world that are consistent with that. There is a case called Karahar Bodes in Hong Kong. There's a case called Koa Clerici, an English arbitration concerned with enforcement in Australia. I'm not going to go into the details of that now. And finally, there's the case of the Astro Nusantara, which I imagine many of you are familiar with here. That is a well-known case, certainly both here and in Singapore. It's given rise to many issues. That was a case, very briefly, where you had a Singapore seat arbitration in Singapore. The tribunal, the arbitral tribunal, decided in a preliminary ruling on jurisdiction that certain third parties could become additional parties to the arbitration, and on that basis they issued enforcement proceedings in various jurisdictions, including Hong Kong and Singapore. The time limit to resist enforcement expired in Hong Kong some time ago in 2010, and on the basis of that decision by the tribunal in Singapore, judgment was obtained in Hong Kong, and on that basis the claimant obtained a garnishee order in Hong Kong on the basis of that. Thereafter, there were separate enforcement proceedings in Singapore. The Singapore Court of Appeal held that, contrary to what the tribunal had held, the tribunal did not have jurisdiction to add in third parties and refused enforcement in Singapore. One then got into this rather odd position that in Hong Kong there was a binding judgment on the basis of the award, and thereafter in Singapore, which was the seat of the arbitration, the Singapore Court of Appeal overturned the award. The defendant in that case, who had not resisted enforcement originally in Hong Kong because they thought there were no assets in Hong Kong, then came back to Hong Kong to try to set aside the award in Hong Kong, some I think 5 years later, on the basis of the decision of the Court of Appeal in Singapore, which now had set aside the award. And the judge, I think Justice Chow, decided that although the Singapore Court of Appeal had set aside the original award, that didn't matter in Hong Kong, because in Hong Kong there was a judgment, the defendant had not resisted in Hong Kong, the time limit for resisting in Hong Kong had expired, and it was far too late. I summarize it, that's sufficient. It was too late to set aside the judgment in Hong Kong, even though, as I have said, it had the original award had been set aside in the country of the seat of the arbitration. Now, I understand Astro Nusantara is going to the further, and I'm not here to tell you whether or not that decision is right or not, particularly because it depends very much on Hong Kong law as to the approach to a defendant who does not resist enforcement and some years later, much after the time, wakes up and decides to try to set it aside at that stage. That may involve questions of local discretion that I don't want to get involved in. But importantly, Justice Chow decided, he made his decision, even though he recognized, he said, that the decision of the Court of Appeal in Singapore overturning the award created an issue estoppel in Hong Kong. And that is probably the most amazing thing about Astro Nusantara, and that is the Hong Kong court, considering an application to set aside one of its own judgments, recognized that the effect of the foreign court in Singapore, which overturned the original decision of the award, created an issue estoppel as a matter of law in Hong Kong. Nevertheless, because of discretionary factors, the Hong Kong court was not persuaded to set aside its judgment. And if you're looking at Astro Nusantara, oh yes, it's paragraphs 94 to 96 that I am concerned with. So, finally, I go back to Our Lady. I was going to go and say I'd go back to my mobile phone just to see, because I was told that at 1:10 local time we would know whether Ed Miliband had won or whether David Cameron had won, much more important than Astro Nusantara. Let's go back to this lady. How on earth does this fit in with Diag? Why did this great international, go back to my case Diag, why did this great international arbitrator accuse me of falling asleep? And to do that, let's go back finally, and I hope quickly, to the convention. Go back to Diag just for a moment. Diag, you remember, is a Czech award, but there was this internal process depending upon whether... I'm sorry? It was against the Czech... It was against the Czech... Yes, absolutely right. Against the Czech government, Czech Republic. Czech award against the Czech Republic. Had an award in favor of the claimant with this pending appeal internal appeal. It was uncertain at that stage whether it was binding or not, but the Austrian Court of Appeal, Supreme Court, had held that it was not binding. Did that decision create an issue estoppel in England? Now, if we go back to the convention, why this international arbitrator says I am wrong is as follows. That if you look at it, it says recognition and enforcement of the award may be refused. So I did refuse enforcement of this award, may be refused at the request of the party against whom it is invoked only. So I did refuse it. The question was, does it fall within any of these subparagraphs? And what this international arbitrator says is that these paragraphs are exclusive. They create a complete, exhaustive code as to the circumstances in which the court may refuse. But if you don't fall within the subparagraphs, the discretion to refuse does not arise. And if you look at little e, the question is the award has not yet become binding. And what the arbitrator says is, therefore, the fact that the Austrian court might have decided that the award was not binding is irrelevant to the enforcing court, because the enforcing court has to decide itself whether the award is binding or not. It cannot escape that judicial function by saying, well, another country has already decided that it's binding. It is the duty of the court under the convention, of the enforcing court, to decide whether or not the original award was binding or is binding or not. And therefore, this writer has said that I was wrong, because issue estoppel is not one of the recognized conditions which may allow the local enforcing court to refuse enforcement. So he says, basically, that issue estoppel is irrelevant under the New York Convention. As I say, I'm not here to tell you my decision was right or not, but two things, and then I will sit down, or at least invite any questions. 2 points. First, that point was never argued in my case under the New York Convention. That may not matter, but it was never argued. But secondly, and perhaps more importantly, in deciding whether the award has not yet become binding, the local court, as it seems to me, must decide that question by virtue of its own domestic rules. And one of those rules may be that there is an issue estoppel, and it may be that the English court or any other court will say that it has not yet become binding because the party who is seeking to enforce it is stopped from saying that it is binding because of the previous decision. And therefore, to that extent, issue estoppel may come into it. There are very, very strong views about Diag. There are very, very strong views, because if you go back to my diagram, if there is the prospect of an issue estoppel, in these modern times where if you can forum shop, can you go from country A to B to C to D, you win in one, can you lose in another? Or if you lose in one, can you have another bite at the cherry in a different court? As I say, put public policy on one side. There is a view, and I think it's fair to say that I don't know where Hong Kong fits into this, but the English lawyer's view is that issue estoppel probably does work, but it does exist under this concept, but perhaps the civilian lawyer's view is that it does not. And but that may be for other cases. Anyway, I leave you, if I may, with a lady to say, I'm not sure at the moment what the right answer is, but it's certainly something that may arise in a future case. Anyway, thank you very much for listening. Thank you for giving up an important part of the middle of your day. And if there are any questions, certainly I'll happily take them. But thank you very much.
we have about 15 minutes for questions or comments.
I would like to ask a question, if I may. Is Astro Nusantara, does anyone know, is it going to the Court of Appeal here or not? Does anyone know? It is. Does anyone know, it's quite a recent case, isn't it? So I'm not sure when it will be in the Court of Appeal. I see. Was. Right. Well, I think the decision itself is very controversial, as much in Singapore as it is here, and that's why I hope I try to focus in the case on the one issue, or the one point, not to use the word issue, the one point, which is perhaps, but certainly wasn't essential to the decision of Mr. Justice Chow himself in that case. Yes, Richard. I said no heckling, Richard. Well, a number of answers to that. The first is, when I say successful, I think what I mean is, I think it's the greatest number of state parties who have subscribed to any international convention, I think by a very large margin. So it's successful in that sense. But the second question is, I was not there in the smoke-filled rooms, perhaps in 1958, I think it was, when perhaps people were negotiating the word may and the word only. Because the way it is phrased, if one stands back, is rather odd. Other people will say it's not odd. But as I say, it gives the enforcing country, I'm going to use the word a discretion, because that's the word may. It gives the enforcing country a discretion whether to enforce or not, even if the award is set aside in the seat of the arbitration. And if one thinks of Richard's question there, if that is right, then I'm not sure that it can properly be described as a great successful convention in that way. And English law, however, takes the view that the word may, although in one sense it's an open discretion on the face of it, the cases that I referred to earlier are in fact, the discretion is limited in very strict way to cases where the award is set aside and where it can be shown that that setting aside was the result of some fraud or some improper practice by the court, which is a very rare event. So English law takes a very narrow view of the word may. But other courts may not. But the third point to make, perhaps, is I don't know the answer to your question, Richard, in the sense that if any student anywhere in the world would like to do an analysis of the cases in all the jurisdictions in which an award the award has been refused, or enforcement or recognition has been refused, and the reasons for that refusal, that would certainly be an excellent project. If you go to the New York Convention website, you will see the cases there. And it may be that there is already studies about this. There may be. I think it's fair to say that I think this problem is, to a certain extent, a recent problem. That's my impression. But I'm not sure I can do better than that, Richard. Yes.
Before ordering enforcement, to see how the curial court gets on with the process. That seems to me to open up, I think I'm expressing the law correctly, the Nigerian case to that effect.
Yes.
That seems to me to be a further recipe for ineffectiveness under the convention.
You are right. You are right. I haven't got it here, but I think it's a later article in the convention, certainly in the English Act. I think it's section 103(6) or something like that, where the English court can effectively adjourn the question of whether or not to enforce in circumstances where there are pending proceedings in the seat of the curial court, in the seat of the arbitration, about that. But you are right, particularly where, for example, the curial court, the seat of the arbitration, the proceedings there may take a very long time. And not only at first instance in the foreign court, but maybe a court of appeal may be going up further. And if one looks at the New York Convention, which was intended to create a regime of fast, easy enforcement, if, as you say, that possibility arises, then that does create, and if it is used too liberally, I might describe it in that way, that creates or potentially creates a real problem. Therefore, going back to your question, is it a successful convention or not? Certainly, as I said, successful, I intended to mean successful in the sense of number of parties coming to it. Is it successful in the sense of creating a regime of easy enforcement? I think that is perhaps more questionable. That's all. Certainly, I think English law is very pro-arbitration. There is no doubt at all about that. As with many other courts, I would imagine Hong Kong is as well, but pro-arbitration. But one has to be a little careful with the concept of pro-arbitration. I don't know if there's someone called Toby Landau who gave a great speech in Singapore recently, which his point was that where a local court sets aside a decision of a tribunal because the decision of the tribunal is wrong, for whatever reason, that doesn't mean that the court is being anti-arbitration. On the contrary, it is being pro-arbitration because what it is doing is making sure that the arbitrators are doing their job properly. That doesn't mean that the local court will overturn questions of fact, but in terms of, for example, only due process, if I might use that term, it is important, it seems to me, that the courts maintain a supervisory jurisdiction which ensures that the arbitral process is done properly. But short of that, I think the courts are there to be proactive in terms of enforcing awards quickly, easily, and cheaply. And certainly that was the idea behind the New York Convention. I think there is a lecture almost every day around the world, Richard, about whether or not the New York Convention works or not. And there are very different views about that.
If I may just, this question is fascinating. I think one thought just came to mind when you were speaking about due process. The seat may set aside awards based on due process or based on public policy. This idea that some award is contrary. And so is this question of whether in the enforcing jurisdiction, whether or not issue estoppel applies. Could it have something to do, or in the New York Convention, this sort of scope given to the enforcing jurisdiction, could that be one way of testing the impartiality and independence of the seat's determination? And that's to say that in some cases, some may say this is contrary to public policy for other reasons. They say it's an investor state and it's contrary to public policy because the state doesn't wish to honor it. So is this giving them the enforcing jurisdiction some scope?
Well, certainly I've gone back to that, the screen on, with the convention in it. Certainly under subparagraph 2, Article 5.2, one's looking at the public policy of the enforcing court there, and there may be any number of reasons why the local court may take the view that the award should not be enforced. You are absolutely right. I have not done an analysis of all the New York Convention countries, but certainly in England, for example, and I summarize it that badly, but the court can only, on an appeal, overturn an award on a question of law arising out of the award. It's a very narrow test. In other countries, it may be that the ability of the local court to set aside an award is much broader, even apart from questions of public policy, much broader. So the New York Convention doesn't tell anybody how easy or difficult it may be to enforce an award. And importantly, going back to one, it's really the very first point that I made, and that is that the fact that the curial court, the court of the seat of the arbitration, sets aside an award, does not necessarily mean that it will not be enforced in the third country, in the enforcing court.
We have time maybe for one final question or comment. Yes.
I'm not sure I heard all of it, but can I just make 2 points clear? Article 5.1 is in 2 parts, really. The first is you've got to get yourself within what I call the gateway. So you've got to get yourself specifically within either A, B, C, D, I haven't copied them there, or E. That's the first question. The second question is, if you do get yourself within the gateways, then a discretion arises. But there is no discretion, apparently, under Article 5, if you don't get through the gateways. And therefore, going back to Diag, and I'm not sure I understood the last part. Yes. Yes. I had not thought of that before. It's not what I had. It may be, but I've never known that. I've never heard that argued. I think I've looked at, in preparing certainly for today, and not only for this lecture, but because of the storm that Diag has caused, I have spent some time looking at virtually any case that discussed issue estoppel, in order to enable me to go around the world saying that Diag is right. But I haven't been able to go that far yet. The administration of justice, I'll do this, I'll go back and see whether you may be right, because if that's possible, then I would be certainly keen to adopt it. It is odd, just going back, and just looking at it very broadly. It just sounds wrong that a party can, forget about public policy just for a moment, it seems wrong that an award is published in country A, there is no decision of the curial court, the claimant goes to country B, and an eminent court, if I might describe it in that way, like the Austrian Supreme Court or like the Hong Kong Supreme Court here, decides it is not binding. The idea that the claimant can then go to country B or country C and have a complete hearing again, and if he loses there, can go to country D and then go to country E, It just seems odd that a party should be able to do that. Certainly in England, there's a great view that forum shopping, if that's the right way of describing it, a party going from country to country, that is not an attractive prospect. I'm not saying it's impossible. So there is at least an argument in favor of an issue estoppel. My own, I'm not saying my own, one possibility anyway, is that, as I said, going back to that, do you remember that paragraph 4, I think, that Lord Justice Clark, paragraph 4 of Lord Justice Clark in The Good Challenger. It's important that it's not even a doctrine, but the concept of issue estoppel should not be used mechanically. And it may be, one may be able to say in a particular case, yes, this would create an issue estoppel, but some question of justice overrides that in that some way. It's not a discretion, but it gets it that way. That may be the way. But I promise you I will go away and look at subparagraph B. Okay.
With that, I'd like to invite you to join me in thanking our speaker today, and thank you also for your participation.
Thank you very much. Thank you.